Namaste ji, namaste. So in the previous lecture, we discussed mens rea and actus reus. Now we're going to discuss a bit about general exceptions. More details obviously are in the course, but I'm going to basically demonstrate to you how do you write the answer and what do you base it on when you're writing an answer on general exceptions. So things to quote. We're starting from things to quote, and these things you cannot write an answer in the UPSC law optional without mentioning these things, because these things are going to give you marks. So which chapter of the IPC are general exceptions given? So that's chapter 4 of the IPC. Then you have to mention article 361. You're going to draw an analogy and going to compare it. What is 361? I'm sure that you have done your GS ki theory by now, right? Constitution. President, Governor, Raj Pramukh exempt from criminal liability. And something we're going to do in general exceptions as well. Obviously the concept is entirely different, but this can be quoted to tell the examiner that look, we know pretty much that another thing is given in the Constitution, which is basically talking about a very similar yet different thing. Okay, so 361 is here. Then what are we going to quote? Section 105 of the Indian Evidence Act. You need not quote entire sections word to word in your answers, but pretty much let us say when you're talking about section 105 of the Indian Evidence Act and you mention the standard of proof, the burden of proof, basically the burden of proof is in this, the onus probandi lies on the person who's trying to claim an exception under these sections has to prove it themselves. Basically the burden of proof lies on you. If you say that your case falls under any of the general exceptions that are given in the IPC, who's going to prove it? The prosecution? No. You are basically trying to take the benefit, so your counsel basically is going to take this up in the court. And with that, with sections of the IPC, 76 to 106, private defenses, 96 to 106, all right? And then one more thing that you're going to always mention is section 6 of the IPC, because homework for you, read section 6 of the IPC. What does section 6 of the IPC say? That everything given in the IPC, I'm just giving a broad overview of what is given in section 6. I'm not going to read out entire word to word section 6. Section 6 says anything that is given in the IPC is subject to general exceptions. So you'll have to consider, the court has to always consider the general exceptions whenever it's reading an offense, all right? And sections I've already mentioned, 76 to 106, these things need to be on your tips first and foremost. Then general exceptions can be broadly classified into two. So the one is excusable, one is justifiable. So acts which are excusable, so if you belong to a certain class of people, you are excused. So for example, let us say section 82 of the IPC says, nothing is an offense which is done by a child under less than 7 years of age. Who is less than 7 years of age? Well, great. So if you are like a child of 5 years and you commit murder, well, that's it. It's nothing is an offense. Basically, it's nothing. Everything is excused. So we are excusing you just because you belong to a certain category of people, right? And then there are some acts such as they are justified. So whenever, obviously this all is given in sections as well, but if you can, illustrate that you have understood pretty much with the use of common everyday examples and not more than 1 to 2, because you need to manage your time as well. So for example, let us say that somebody comes running at you with an axe, and you pretty much know that if you don't kill this guy right now, and he's a lunatic with an axe and he's just coming to kill you, and you kill him in defending your body. Where is right to life given in the Constitution? That's 21 under part 3, right? So that's a fundamental right, okay? You have a right to life, thanks to which, therefore, we have these sections in alignment with that article as well. That what was your mens rea in this? That the lunatic is coming at you with an axe. What was your mens rea exactly? To kill the other person or to protect yourself? To protect yourself. So using mens rea and actus reus, the concepts that are given in the previous lecture, you will have to discuss that usually in general exceptions, mens rea is basically the crucial factor in deciding whether you'll get the exception or you'll get the benefit of the exception of the section to you in your case or not. So you'll have to illustrate to the examiner that you have understood the concept of mens rea. So mens rea and actus reus also comes in this column. You cannot write an answer on general exceptions without going into at least basics of mens rea, in which you explain to the examiner that, look, buddy, I know the entire IPC is basically based on a combination of these two factors. Except for the strict liability offenses, those are completely separate stories. So if now this is missing, I can pretty much go into the exception. So for example, let us say that somebody at a party spikes your drink, and then you wake up and people tell you, well, buddy, you've stabbed another person and now you're going to jail. And then you're like, I didn't have any intention to stab anyone. I didn't even know in which state I was, right? You had no pretty much capacity of mind to form any intention to even stab someone, but since you were so high, you didn't know what you were doing. But can we really prosecute you for such a thing in which you didn't even intend to do it, right? And I'm not talking about murder here, that's a separate story. I'm just talking about stabbing someone and giving them an injury. Can you take an exception? When we come to the depths of the section, basically when we discuss the sections, we'll have to take this up. But a crucial thing is that you list out the illustrations from these sections, all right? So for example, let us say, so you can also, in your answer, to make it better, you can actually sub-classify the sections into broad categories such as this. So mistake of facts relates to 76 and 79 is relating to mistake of fact. Judicial acts are given in 77, 78. Basically, judicial acts are exempted, so it's a general exception there. Accident, misfortune happens, so that's 80 and 81. Infancies, 82 and 83, and then we keep on going till 106. We're not going to go enter into those details here, but let us take a look at the illustration. So for example, let us say that there is one guy, Nitish, and then there is one woman, Tanya. He sees the woman murdering someone, and let us say that this guy is Mukul. So Tanya is murdering Mukul, and Nitish arrives on the scene and just sees that if he doesn't stop Tanya right now, she's going to murder Mukul. All right. So what does Nitish do is Nitish apprehends Tanya and just gives her to the police. And later on, it is found out actually Mukul was the one who first came in and attempted to murder Tanya. But Tanya, as usual, she's a smart woman. She actually attacked him back and was trying to save herself by murdering him. But Nitish ji ko to ye baat pata nahi thi. So Nitish ji couldn't be, Sherlock Holmes at the spot, and therefore just handed Tanya over. But can Nitish be prosecuted for this act for falsely apprehending someone? What was Nitish's mens rea here? To prevent a murder. Was Nitish's mens rea to falsely arrest someone and just send them to jail? What was the mens rea? What was the intention? The intention was to prevent a murder from happening. And if we allow Nitish to get prosecuted, well then we'll basically fail the concept of justice to begin with. I mean, why फिर न्यायपालिका बैठेगी क्यों जब न्याय ही नहीं होगा यहाँ पे? Why are we going to sit, right? So Nitish ji basically won't be prosecuted. He'll take the exception of 79, and this is basically the illustration of 79. Now let's take the illustration of 80. For example, let us say that you are working with a hatchet. That you are kulhadi hoti hai. I'll just put the picture here. Choti si. This is basically the machine, rather the tool that you're using, and you are just अब अपना काम कर रहे हैं, लक्कड़ वक्कड़ काट रहे हैं, whatever it is. And then suddenly, there's this one person who's standing right next to you. You have no intention of doing this, but the head of basically this tool, the metal head, just flies off and goes ahead and cuts the other person's head off. And you're like, bloody hell. Did you ever intend to do this? Did you know that your action could do this? That's the illustration to basically 80. It is an accident, right? It has just happened purely by chance. Can we prosecute you? Obviously, you'll go to trial, police will take you to jail, and they're going to present to you as per at an appropriate court. Usually in this case, it will be a sessions judge. And can you be prosecuted? What will your defense counsel take the exception of? Section 80. Homework for you. Read section 80. Right. 81 talks about the doctrine of necessity, in which you choose the lesser evil out of, let's say that there are two evils, you choose the lesser one. You know that your act will cause slight harm, but you are actually averting some bigger harm. Read illustration of 81 on your own. All right. Now 77, 78 is something similar to Article 105, 121, 122 of the Constitution, which judges and their basically the staff of the court is exempted, provided that they are acting judicially and in good faith. They believe that they have such power. All right. So, for example, let us say that the court issues a warrant of arrest, and then the officer of the court basically, let's say, just not to make the legal discussion any more complex, like police officer goes and executes that warrant and arrests you. Later on, we find out that the court never had any jurisdiction to actually issue that warrant of arrest, and that's under Chapter 6 of the CRPC. Sections 70 onwards. So you need not mention CRPC in your UPSC law option, by the way, the answers. So now do we prosecute that police officer, but he believed in good faith that that the court had jurisdiction? Because if we start doing this, well, we're done for. And under 77, let us say that the judge in good faith believes that he has such a power to do something, to do an act, let us say, and then later on it is found out that he had no power. But then the judge believed in good faith, and then he was acting judicially as well. So he was well within his right to do something. Do we prosecute him for that? Because otherwise then judges will forever be under the reservation, and the officers of the court will also be in the reservation. If I do this, what if I'm prosecuted, right? Similar funda with absolute freedom of speech in parliament, that's parliamentary privileges, right? And parliamentary proceedings not to be discussed in courts, court proceedings not to be discussed in parliament, right? 121, 122, 105. GS revise karenge. Achha, one more interesting thing is 76 is that mistake of act under basically when you're bound by law to do something. So let us say that there is a soldier who under the command of the superior officer. So for example, let us say that there is some protest happening at Jantar Mantar, which usually keeps on happening, and a peaceful protest is happening, and some nefarious elements and some violent elements basically enter into the protest and start to burn buses and start to beat up the police. So the commanding officer then tells his inferior to just fire at the mob, and the junior officer actually does so. Then can he be prosecuted? No. That's the illustration of 76. That if you are bound by law to commit an act, it is a general exception. Now why is it so? So on the one hand, we are telling the soldier or the officer, inferior officer, that you are going to follow your superior's order under any circumstances. You're bound by law to do it. And on the other hand, let us say that we don't give them this exception. So basically, it's a huge contradiction. One hand, we're going to say that you follow. On the other hand, you say if you follow, we're going to prosecute. Well, then you're stuck in the middle, right? So 76 illustration, usually people get confused, and it appears a lot in judiciary prelims and LLM as well, that a soldier who is, let me just read it out from the Bare Act for you. A soldier fires on a mob by the order of his superior officer in conformity with the commands of the law, by the way. A has committed no offense. Wow. See? So we need to now, this is pretty much easy. So we need to connect everything, mostly the illustrations, with the concept of mens rea and actus reus. And we need to mention, to demonstrate to the examiner that, hey buddy, we know what we're talking about here. And general exceptions ke saath aap hamesha ye likh ke aayenge, excusable and justifiable. And if possible, you're going to subclassify the sections like this, maybe even under these broad two heads. So you need not write sections word to word, but the illustrations from the sections, if you can connect with the concept of mens rea and actus reus, that will demonstrate to the examiner that the funda of general exceptions in the IPC is clear to you, right? Because now, remember, we're not, so for a judiciary exam, we need to basically, in the mains pretty much, demonstrate that we know general exceptions, and by using those general exceptions, we can give you a decision. But for the UPSC law optional, we need to demonstrate to the examiner that we know the IPC, we know the funda, we know the theory of the IPC, and we can connect that theory with the illustrations that the IPC is using. So we can basically tell the examiner we know why the law is the way it is, and that will fetch us a beautiful amount of marks. And that is the main thing that you need to do with your answers in the UPSC law option. So teaching all of this is pretty much very easy, to tell you very honestly. Writing the answer is a tad bit difficult, and that's what we are doing in our course as well. So if you want to discuss all of these in more details, you can check the course links in the description. And yeah, we'll be putting out a good amount of lectures on YouTube as well. All right. Take care. Wishing you all the very best. Get into the mode of answer writing, in which you can demonstrate to the examiner that you've understood why the law is the way it is, especially in UPSC law. All right. Take care. Bye.